not receiving the summary, you can email any of the presenters and we'll get you on our list. Also, if you have any topics that you don't see that are being covered and that you would like for us to cover, please let us know. A bit of housekeeping before we get started. You can see there's a question and answer widget at the bottom of your screen. Please submit your questions. We certainly will try to answer them at the end of the program. The presenters will stay on, understanding that many of the people attending may not be able to do that, but we will try to stay on as long as we can to answer questions if need be, or you can email us and we'll see your email address that you submitted. We'll get back to you if we don't have time to answer your question. There's also a resource widget where you can get the slide deck and other materials from Thompson Coburn's practice group. And there's a help widget if you have IT issues. Additionally, there's a post-webinar survey. We would like to hear from you. Whether it's good or bad, we like all comments, we like feedback on the topics, on the presenters, and how we did today. Additionally, there is CLE credit for Missouri, Texas, California, Illinois, and New York. There will be some secret words throughout the presentation. I believe there's 3 of them. We will make that known. We will certainly let you know what the secret word is and give you 15 seconds or so to enter the secret word. If for some reason you miss a secret word, you can certainly ask us in the question answer widget and we'll provide you information on the secret word. I wouldn't be much of a lawyer if I didn't disclaim everything we're about to tell you, because it's not legal advice. This is informational. If you do have questions and require legal advice, please get with your outside counsel. If you don't have outside counsel, we would love to become your outside counsel. So email us and we can set up a meeting and see if we can help you in any way. Every good course has a syllabus. Our webinar is no different. So today you will hear from me regarding gainful employment and financial value transparency litigation, the borrower defense to repayment litigation, and how OB3 has affected both of those cases. Then you'll hear from my colleague Grant Hill on grant termination litigation. And then actually Lori is going to go third with DEI and DOJ guidance. And then Anna will end with the False Claims Act and the key TAM provision, and we'll save some time for questioning at the end. So let's get started. Everyone, I'm sure, is aware that on October 10th, 2023, the Department of Education published the Biden-era financial value transparency and gainful employment rule. Under this rule, the department will calculate debt to earnings ratio and come up with an earnings premium metric for every Title IV program, whether they're GE or non-GE programs. And this rule took effect on July 1st, 2024. It is still fully in effect today. But prior to its implementation, there were 2 lawsuits filed, both in the Northern District of Texas, attempting to prevent the coming into force of the Biden-era gainful employment rule. In June of 2024, and this is important, just prior to the Supreme Court's landmark decision in Loper-Bright in the summer of 2024, the district court declined to grant the petitioners a preliminary injunction in the gainful employment litigation. And then the 2 suits were consolidated. Fast forward a bit to post-election. So now Trump is in the White House as opposed to Biden. And the Trump administration asked for a 90-day stay so they could reassess the gainful employment litigation. Then came a shocker. Many of you may remember this. In the spring of this year, on May 16th of 2025, the Trump administration revealed that it intended to sort of full throat defend the Biden-era gainful employment rule. This was quite a shocker, considering that in 2019, when the Trump administration stripped a very similar gainful employment rule from the Obama administration, the Trump administration called the previous gainful employment rule fundamentally flawed, inconsistent, said it failed to properly account for factors, it failed to provide transparency, it wrongfully targeted some programs while ignoring other programs. And again, this was an attack on the Obama-era rule, and the Biden-era rule was very similar. So again, everyone was very surprised at the administration's action in that case. This summer, The plaintiffs in the gainful employment litigation requested oral arguments on the parties' cross motions for summary judgment. The standard for a motion for summary judgment and preliminary injunction are not identical, but I want to bring up that, we don't know if there'll be oral arguments. The court could certainly grant that. It's been some time since the request. It has not done so. There could be a decision dropped at any time. But what's important from our perspective is that the court didn't use the Loper-Bright analysis in the preliminary injunction standard. And even though the summary judgment standard is different, they will use, the court should use at least, the Loper-Bright analysis for the motion for summary judgment. And so we could get quite a different ruling than we got on the motion for preliminary injunction. We'll just have to stay tuned to see what happens. And when I talk about the Loper-Bright standard, for those who may not quite remember, what that means is that the court now will scrutinize the department's interpretation of gainful employment and see if that is consistent with the plain meaning of the statute, as opposed to prior to Loper-Bright, the Department of Education would receive deference in how they viewed the rule. Now, how does OB3 affect gainful employment? I'm sure everyone is aware of the new Do No Harm accountability framework that's now part of the Higher Education Act, thanks to the One Big Beautiful Bill. And at least presently, the Do No Harm framework is in addition to gainful employment and financial value transparency. It does not replace it. Importantly, keep in mind that everyone, all institutions, will have to certify next summer on July 1st, in their PPAs that they are in compliance with the new Do No Harm framework. Again, the department's got to put a lot of meat on the bones between now and then, but everyone should be paying attention to the guidance that comes out with Do No Harm, because very soon all institutions will have to certify compliance. Now, what programs will the Do No Harm framework apply to? The Congress did not detail the full universe, but what it says in the statute is that it shall apply to an undergraduate degree, graduate degree, or professional degree, right? So we're going to take some hints from the previous gainful employment rules and sort of guess at this point what's covered. So our best guess is that associate's degrees, bachelor degrees, master's, doctoral, first professional degrees, the ones that in the PowerPoint here are in the orange, we think that those are covered under gainful employment. We think those same types of programs will be covered under Do No Harm, and we think undergraduate certificates and post-baccalaureate certificates will not be covered. Now, again, that's what we believe. We're trying to read the tea leaves a bit, but keep your ear to the ground for guidance from the department. Again, talking about reading the tea leaves, what's going to happen with gainful employment, and why did the Trump administration, why were they so inclined to defend the Biden era rule? Well, my personal opinion is that I think this administration is very interested in data, and I think it wasn't so much the gainful employment enforcement side that interested this administration, but the financial value transparency side, where every Title IV institution has to provide information regarding every program. I think that information is very important to the department and this administration. And so whether that's through GE or whether that information is going to be gathered through Do No Harm, I would expect those requirements to stay in place. Will gainful employment survive? I think there's two ways it could go away. One, obviously through the litigation in the Northern District of Texas, but also it could go away through some future negotiated rulemaking, maybe some type of settlement in the litigation. Again, we shall see, but most people suspect that ultimately we'll probably down to, maybe one enforcement would Do No Harm, but again, we shall see. And then finally, what will be the framework? What will be the details of Do No Harm? I think that that's a lot to be seen. I don't know if that'll be covered in a future negotiated rulemaking or guidance from the department, but certainly the details must be fleshed out. And so please keep your attention to that. And obviously our practice group will be submitting blogs and other information as information becomes available. Now, importantly, Do not forget these two dates. Next Tuesday, September 30th, there is reporting information required under gainful employment. It is covering award years 22 and 23 and 23 and 24. So please, if you're not prepared to make that disclosure to the department under gainful employment, please do so next Tuesday, September 30th. The very next day, on October 1st, 2025, the award year 24 and 25 is due. So you've got, and that's next Wednesday. So you've got, if you haven't started, some work to do between now and next week. There's nothing we have seen that has stayed these deadlines. We have not heard that these deadlines will be stayed. So be prepared to make those disclosures. The bar defense litigation, BDR. I'm sure everyone is aware that the Biden administration published the 2022 BDR rule that was set to take force on July 1st, 2023. But in February of 2023, before the rule came into effect, Career College School Group sued in the Western District of Texas. And initially, the district court there declined to issue a preliminary injunction. But the Fifth Circuit Court of Appeals stepped in, and in April of 2024, it directed the district court, April of 2024, it directed the district court to enter a national injunction. And that is where that litigation stood until October of 2024. And again, obviously paying attention to the calendar, this is still when Biden's in the White House, and the department petitioned the Supreme Court to review the Fifth Circuit's injunction. And in January 2025, prior to Trump coming into office, the Supreme Court granted the petition and was ready to hear the arguments. January 24th, 2025, President Trump has been in office for 4 days. The department files a motion to hold the briefing schedule in abeyance, very similar to what they did in the GE litigation, just to allow the department to reassess the basis for the litigation. The parties went back and forth. There was some indication that possibly, like gainful employment, the administration would defend the Biden BDR rule. But after the passage of OB3, the parties decided to dismiss the Supreme Court appeal. So we will not be getting a Supreme Court decision on the validity of BDR. But how did OB3 affect that litigation? Well, in OB3, in Section 85001A, what it did is it delayed the Biden administration's 2020 rule essentially for 10 years. And the reason this occurred, it was a parliamentary reason. The Senate could not extend this deadline more than 10 years without getting 60 votes. So instead of officially repealing the 2022 BDR rule, it extended it back to 2035, but it cannot become valid until 2035. And obviously, most people think, something will happen with BDR between now and then. And additionally, OB3 also put the Trump administration's 2019 rule back into full effect. So under the law, it has been in full effect since 2019 and remains in full effect today. One thing to keep in mind with BDR, and to the extent that you get BDR claims, you've got questions about BDR, every time a new rule comes in, it doesn't replace the old rule. So you need a bit of a chart to understand which rule was valid and when. And we've got such a chart for you. And, you've got the year rule at the top. But what's important more than the year is underneath, it has the years that apply to the rule. And so keep this chart handy. If you ever get a BDR claim, you can review this, and then you can see which rule applies to the institution. Bonus topic, this wasn't even on the syllabus. We will start tracking this litigation in our summary, but there was a case filed over the summer in the Eastern District of Missouri, the Hannibal LaGrange University suit. This is a nonprofit, religious affiliated institution, and it has challenged the department's signature requirements regarding ownership. I mean, that's a topic that's important to many, and this case is ongoing. A bit of inside information we're hearing, scuttlebutt on the street, is that there may be a settlement reached in this case. Again, I mean, nothing's confirmed until it is, so we don't know. We don't know what the settlement would look like. But a settlement may, and I say may, we'll have to see, affect all signatory requirements going forward for institutions and their PPA. Be on the look. I'm sure we'll issue some type of blog or other alert if something changes here, but it will also be in our litigation summary going forward. And with that, we've got our first secret word, and I don't know what the correct answer is. Let's see. Oh, let me go back. That may have been in our key, but I don't have it. It is litigation. Sorry for that delay. That is my fault. So it's C, litigation, the secret word, and it was very secret this time. So hopefully everyone had time to get litigation, and we'll give it a few more seconds based on our delay. And with that, I'm going to turn it over to my colleague, Grant Hill, who's going to discuss grant litigation. Grant?
Thank you, Trey, and good afternoon, folks. My name is Brant Hill. Nice to see you all today. And I'm going to cover grant litigation. Thousands of education grants by the Department of Education have been canceled mid-cycle over the past 9 months. And that has spawned an enormous amount of lawsuits being filed against the federal government and the department. So I'm going to cover some basics about these grants, talk about what has happened in these cases, offer some insights into where we may be going, and give some tips to those institutions that participate in these grant programs. Just to level set, there are countless federal education grant programs that the Department of Education administers, that National Institutes of Health administers, and other agencies administer under law. These grants are primarily awarded to post-secondary institutions, and they serve a variety of different purposes, whether providing support to institutions to help certain student groups or to perform scientific research. It would be impossible to cover every type of grant program here, but the important point for today's purposes is that the grants that are being canceled today are all considered discretionary grants. And by discretionary, I mean that the department is allowed to exercise some judgment when deciding who to award the grant to in the first place. And so that's in contrast to mandatory grants or entitlement grants like Pell Grants. Pell Grants and entitlement grants, those are not the ones being canceled. It's discretionary. And the way that the discretionary grant process works is that the department will invite applications for new grants. It'll tell the applicants, here are the criteria that you have to follow in order to be successful in being selected for a grant. And then the agency will hold a grant competition, evaluate the applications, and ultimately award grants to those who are successful. And those grants come with money, of course. And if you get a grant, you're selected, then you've got to meet various requirements to keep that grant. Performance requirements, reporting requirements, you have to comply with Title VI and a whole host of other things. Now, generally, these grants last for a multi-year period. It could be 2, 3, 5 years, or even longer. But funding for the grant from the federal government is done annually. And so every year, these grants will be renewed in the form of what's called a continuation award, so long as the program is meeting its reporting requirements and whatnot. But historically, after a grant is first awarded, it's very rare for the department or any other federal agency to cancel a grant mid-cycle. And as you see here on the screen, the department said as much just last year. And that is equally true for NIH grants. There's been 6 terminated prior to this year over the last 15-year period. Of course, things have changed a little bit. Since this administration took over in January, thousands and thousands of grants have been abruptly terminated midstream. The Department of Education administers many grant programs, as I said earlier, but not all of them have been targeted for cancellation. Some programs have been unscathed, such as those that align more with this administration's priorities, like charter school grant programs. But for other grant programs that are less aligned with this administration's views, the department has been aggressively canceling grants. And so over the past 9 months, as part of the overall plan to shift federal education spending to the states, the department has been reviewing institutions that receive these grants and canceling them. And just because of the sheer number of individual grants that are out there, we're talking tens of thousands of them, the agency hasn't exactly been performing the most careful, individualized review. And in fact, it's been disclosed that the government, at least in some cases, has been using AI software to scan through and detect language in grant applications that have language that are red flags for this administration, whether that be diversity training, restorative justice, vaccine effectiveness, and other similar terms. And the department has been sending very generic boilerplate letters to institutions when they canceled their grants, basically saying, your grant is not aligned with this administration's priorities. Your grant violates Title VI in its ban on race discrimination, or otherwise that your grant it's just not in the best interest of the United States. Now, I don't think anyone would disagree that when a new president comes in, they certainly have the right to devise a new agenda and to carry out their priorities. And I don't think anyone who is filing these lawsuits challenging these cancellations is saying otherwise. What they're saying is that, hey, I applied for a grant back during the Biden administration when we were in a very different political climate. And in fact, the department under the Biden administration encouraged institutions in their applications for grants to promote DEI in their programs, promote diversity training. And so today, by canceling these grants because of language in their applications submitted a few years back, programs are being, to an extent, retroactively penalized based on this administration's current priorities. And really what is particularly concerning for a lot of schools these days is that they are affirmatively reaching out to the department and saying, hey, give me the opportunity to amend my grant documents in a way that will be more aligned with your priorities currently. But they just aren't hearing back. And so that's been a concern. And I would say also that a lot of programs have the right to request reconsideration of the decision by the department, but they are filing those, and also they are just not hearing back. It's just been radio silence.
Brand, this is Trey. I mean, I question, can schools appeal, even if it's a silence or not getting anything back? Is there anything a school can do to appeal one of these decisions regarding the grants?
Yeah, so there is depending on the type of grant, there is a reconsideration or an appeal process, and it is required to be followed. But that has been the problem here for a lot of schools is they are following that process, submitting appeals, submitting requests for reconsideration, but they're just not hearing back. And part of the problem is that the department's regulations do not impose a deadline on the agency itself to respond to a request for reconsideration. And so programs are kind of up in the air about, well, how do we know if we're ever going to hear back? They just don't. And so all of this is really at the core of all the litigation that has been brought over the past 9 months. by those who have been affected by the cancellations, in which they're seeking to get their grants back. They want them reinstated and they want their funding back. And all these lawsuits generally argue that, look, the agency has violated the Administrative Procedure Act, and that's the law that governs federal agency decisions. Agencies cannot make decisions that are arbitrary and capricious, contrary to law, and they have to follow procedure. And if a decision does not follow those standards, a court has the power, a district court has the power to set aside and vacate the decision and enter an injunction that reinstates the grant. And so a lot of plaintiffs were successful earlier this year in getting their grants back and getting their funding back. But there has been a pair of Supreme Court decisions over the past few months that has made things a little bit more complicated. One of these cases involved teacher grants under Title III, the Higher Education Act. These are grants that went to universities, and they were terminated for DEI language in their grant documents. And a group of states where those universities were located sued the Department of Education in federal district court. And initially they got injunctions and they got their grants back. But then the Department of Education went to the Supreme Court and asked for an emergency stay of the injunction, basically just to put it on ice. And when the Supreme Court acts on an emergency request like this, it is acting through what is called the shadow docket.
Brant, you bring that up. What is the shadow docket?
So, yeah, good question. The shadow docket is a process through which the Supreme Court acts on emergency applications for emergency relief. There is typically very little briefing that is conducted on a shadow docket case. There is no oral argument, and the Supreme Court will issue an opinion often that has no reasoning or explanation at all. It will just say granted or not granted. And so it's very different than the normal process through which the Supreme Court issues decisions. In this case, it acted through the shadow docket, and the Supreme Court agreed with the government and basically said that the district court in that case did not have jurisdiction, meaning that it wasn't the right court to decide the claim because of a relatively obscure law called the Tucker Act. And without getting into too many details, what the Tucker Act basically says is that there is this different court. It's called the Court of Federal Claims, and the Court of Federal Claims has exclusive jurisdiction to decide any claim that is based upon a contract with the United States. And the Supreme Court in this case said a grant is basically like a contract, and that these claims for injunctive relief are really just disguised breach of contract claims, because the schools are ultimately seeking money under their grant agreements with the Department of Education. And so the Supreme Court said, you have to go to the Court of Federal Claims if you want to get any relief, if you want to get any money due to the cancellation of your grant.
Brant, a lot of people may not be familiar with the Court of Federal Claims. Can you provide a little more insight on what that court is and what it does?
Yeah, so I don't think a lot of people certainly were very familiar with it several months ago. It is a totally different type of court than the federal district courts that are located in every state in the country. The Court of Federal Claims is a very specialized court that was really created to hear disputes between the federal government and contractors, the people who the government contracts with to provide services to the government. And it never really has heard grant cases, because a grant in some ways is just fundamentally different than a contract under which the government receives services. But with this ruling, and the one I'm about to talk about in a moment, there likely is going to be a lot more grant cases being heard by this court, and this court may not be quite prepared for the onslaught of litigation that's coming its way. Nevertheless, after this ruling, one would have thought that, well, the Supreme Court said all the grant cases have to go to the Court of Federal Claims, so all these cases are going to end up there, right? Well, not exactly. Plaintiffs got very creative, and they found new ways to basically get around the California ruling. Judges, quite a few of them, were sympathetic to these institutions that had their grants canceled, and they found ways through reading the law in their own creative ways to essentially continue to award relief in the form of a grant reinstatement and grant funding to institutions. One of them was a judge in Massachusetts, where a case was filed challenging the termination of NIH research grants. They were also terminated for reasons related to their proposed research on topics that this administration does not favor. And so an injunction was issued by the lower court. And just like in the teacher grant case, government went to the Supreme Court, went to the shadow docket, and once again, the Supreme Court ruled for the government. And that was just last month. And basically, it said the same thing as it had in the California teacher grant case. It said, if you want to get any relief because of a terminated grant, you have to go to the Court of Federal Claims and bring a breach of contract claim. What is notable about this opinion is that Justice Gorsuch called out lower court judges for defying the earlier teacher grant case opinion. And basically what he says is that lower court judges are free to disagree with us, but they are never free to defy the Supreme Court. And I think Justice Gorsuch really is right about that, because at the end of the day, if Supreme Court rulings don't have a binding effect, then you will have chaos in the entire judicial system. There has to be a system of order in which rulings by the high court are meant to bind lower courts and give them guidance on how to apply the law in future cases. Nevertheless, after two rulings, one would have expected that all these cases would go to the Court of Federal Claims, but still plaintiffs are desperately trying to stay in federal district court and get relief there. And you may be asking, what's so bad about the Court of Federal Claims? Well, I think there's a few things. Generally, judges on the Court of Federal Claims are more inclined to rule in favor of the government. And second, there's just not a lot of precedent for grant cases being heard in the Court of Federal Claims. And so I think a lot of institutions that have been affected are apprehensive about doing it. Nevertheless, I do think eventually a lot of these cases may end up there. But they haven't yet, and just a couple weeks ago, I'm sure a lot of folks here are aware, in the litigation involving Harvard, the federal district court in Massachusetts ruled that the government had unlawfully terminated Harvard's grants because it didn't follow the required procedures under law, specifically under Title VI. And the court there specifically rejected the idea that these claims that Harvard had brought had to be heard in the Court of Federal Claims. And so there's clearly some resistance on the part of not only of parties, but also courts to sending these claims and to pursuing these claims in the Court of Federal Claims. And just one thing that's pretty remarkable about that opinion in the Harvard case was the district court judge's comments. She said, quote, "It is unhelpful and unnecessary to criticize district courts for defying the Supreme Court. The Supreme Court's recent emergency docket rulings regarding grant terminations have not been models of clarity and have left many issues unresolved." So the judge was responding to Justice Gorsuch, and not in the kindest way. And so there's clearly just a very serious divide here within the judiciary that is causing chaos and confusion in the grant context. And really is these comments by this district court judge are almost unprecedented in recent times. We just don't see lower court judges being critical of the Supreme Court in their opinions, but here you go. So just a couple takeaways from everything you've heard. The Supreme Court is certainly continuing to rule in favor of the government in the grant litigation context. Despite those rulings, lower courts are finding ways to still rule against the government, keep the cases in their courts, and in doing so, they're really undermining some foundational principles that exist in our judicial system, under which Supreme Court rulings should be binding, and they are binding on lower courts. If I had to guess where this is going next, I think the Supreme Court, sooner or later, perhaps in the Harvard case, will address the question of jurisdiction again, but likely will do so on the merits, not through the shadow docket, and it will issue a much longer, detailed opinion that leaves no question unanswered about what happens in the future in these types of cases. But in the meantime, until that happens, I do think you will continue to see grant litigation happening in federal district courts. I will say that most of these cases, they are not being brought by an individual school whose grant has been canceled. Instead, they're really being brought by associations, organizations on behalf of their members that are institutions, or by states or a group of states on behalf of institutions that are located in their states. Before I hand it over, just a couple quick tips for those who are listening and have a grant. I would review the language in your grant application and your grant documents for alignment with the current administration and its priorities and policies. If your grant gets terminated, I would look at the language that is cited in the cancellation letter. There have been instances in which the letters from the government have just had incorrect citations. And certainly if that happens, you would have an obvious basis to immediately seek reconsideration. I do recommend that institutions follow the appeal and reconsideration process. Those are in the regulations. They're on the screen. Very unlikely that, at least currently in this environment, that you're going to get a response, but it is important to do that so that down the road there won't be an argument by the government that you waived your right to seek relief in court. Finally, if your grant gets terminated, identify other schools that participated in that same grant program, and consider reaching out to them. And if you're a member of an organization, reach out to your organization and see if there is a way to participate in action where you can seek relief through them. So with all that, I will pass it on to my colleague and good friend, Lori Hargrove.
Thank you, Brant. I'm Lori Hargrove, and we are going to discuss primarily today the recent DOJ guidance. I am going to walk through briefly what happened before that. I think everyone is aware of the 2 DEI executive orders that were signed almost immediately after President Trump was inaugurated. They specifically order agencies to terminate, quote, equity-related grants and contracts, end quote. And we have been seeing that this year, as Brant discussed, and we have been seeing grant terminations citing Title VI discrimination violations. Just briefly, these two orders are still in effect. There are two different circuit courts currently considering their viability. One, the Fourth Circuit just heard oral argument in early September in a case challenging them directly dealing with the Department of Education. And the Seventh Circuit is considering a challenge to them in the context of the Department of Labor. And depending on sort of how those decisions shake out, we may end up with a circuit split, which would then go up to the Supreme Court to decide the continued viability of those executive orders. But as for now, they're in place and they're in effect. So let's move on. The February 14th DEI Dear Colleague letter that was published by the Department of Education to clarify and reaffirm the non-discrimination obligations of schools. Let me go back here a second. That letter has been vacated in full, and my sense of that letter is that is sort of dead in the water right now, only because it seems like the department has pivoted and is basing most of its current actions on the Students for Fair Admissions versus Harvard decision. This was a 2023 decision in which the United States Supreme Court held that Harvard's and the University of North Carolina's race-based admissions policies violated the Equal Protection Clause of the 14th Amendment. While this was a case limited to admissions to universities, it used extremely broad language. This is just one example of the broad language it used, which has been quoted by the Department of Education. Eliminating racial discrimination means eliminating all of it. And basically what the department has done is it's using the Harvard decision and expanding it beyond just admissions to and applying it to all aspects of campus life, scholarships, internships, tutoring programs, etc. So let's bring us to the topic of the day. On July 29th, the Department of Justice entered guidance regarding unlawful discrimination. It's very specific. They give very specific examples as to what the department considers to be unlawful. It is non-binding, which means that if you took it to a court would not need to follow it, but it is very important because it gives you a window into exactly what this administration considers to be unlawful, which is certainly important for grant recipients and also important for just any recipient of federal funding. So it gives specific examples of what it considers to be unlawful practices. Let me reiterate that that a race or national origin based classification is not immediately unlawful. It must survive strict scrutiny. There must be a compelling government interest and a narrowly tailored means of achieving that interest. That is a very, very tough standard to meet, which as the Supreme Court has recognized. Gender-based classifications must survive something a little less, heightened scrutiny, not quite as strict scrutiny, but pretty high too. There must be an exceedingly persuasive justification for it and substantial relation to an important government objective. So with those in mind, the July 29th guidance gave very specific examples of what this administration considers to be prohibited discrimination. One is providing benefits in a facially race-based way. So for example, a Black Student Excellence Scholarship. Now, keep in mind that, again, the fact that it's race-based on its face does not automatically make it unlawful, that that then subjects it to strict scrutiny. And remember that one situation that has survived strict scrutiny is when benefits are given on a race-based basis to provide remedies for specific documented acts of past discrimination by the institution itself. If your institution meets this description as to race, national origin, or gender, and I suspect there are several institutions in the country that could meet that, there could be an argument that such scholarships or other benefits are allowed to provide remedies for that specific discrimination by the institution, past discrimination, and thus survive strict scrutiny. Now, remember that under Harvard, there needs to be a time limit to those scholarships or benefits. And Harvard, it had been almost 45 years of using race as a factor in establishing diversity, and the court held that that was too long. There was no end in sight, and it was not sufficiently narrowly tailored enough. So there is risk with that approach. Strict scrutiny is difficult to meet, for one thing, and we'll talk a little bit later about risks in light of what's been happening with grant terminations. Another example that the guidance gives of unlawful discrimination is if a physical space is set aside for a protected group, even if it's considered a safe space. The guidance specifically states the identity-based focus creates a perception of segregation and may foster a hostile environment, even if open to all. Similar to benefits being provided with a facial racial basis, if gender is on the face of a scholarship, for example, women in engineering scholarships, the guidance suggests that it would consider that to be unlawful. The guidance specifically states any program, such as scholarships, that uses race, sex, or any other protected characteristic as a selection criterion, even if framed as addressing underrepresentation, is an unlawful practice. So, women in engineering, I think the rationale for that has always been that women are underrepresented in the engineering field. Well, this directly addresses that and suggests that those scholarships would be unlawful, unless, of course, they can meet heightened scrutiny for some reason. Another example, which surprised many people, is that the guidance suggests that using first generation or low income scholarships could be unlawful if they are used as proxies for race or national origin. Now, keep in mind, first generation scholarships and low income scholarships are obviously facially neutral. When applied to all and awarded to all, they're not illegal. But what the guidance is addressing is if you're using those as proxies, you may be offering them to all, but you're awarding them just as to a particular protected group, then those would be unlawful. It also mentions geographic targeting. If an entity is targeting a particular geographic area for recruitment, primarily because of the racial or ethnic composition in that area, that would be considered unlawful. I did want to bring up, in the context of just the idea of geographic targeting, some institutions have very set admissions policies where they set, particularly state institutions, where they have a policy that they will automatically admit students from, for example, the top 10% in any high school in the state. And obviously that's not targeting a particular geography. It's actually, arguably including the entire geography of the state. This guidance suggests that you look at the intent behind that policy. If the intent behind the policy is to create more racial and ethnic diversity, then this guidance suggests that could be unlawful as well. Other examples, just briefly, programs seeking gender balance We have seen a grant termination in the last month where it was terminated because the program that the grant was being provided for sought an equal number of men and women, and it was terminated for that reason. Placing people in mandatory groups, not voluntary groups, but mandatory groups based on race, sex, national origin, and then using other proxies for race in applications such as cultural competence, lived experience, overcoming obstacles, or cross-cultural skills. These were mentioned specifically in the context of employment, but obviously the guidance could be interpreted to be broader than that. It does not specifically mention what we call the essay exception that was established in Harvard. Harvard allows essays that seek unique student experience, even as to race, to be considered as to the individual, but not proxies for admitting a particular protected group. Now, the February 14th Dear Colleague letter did specifically quote the Harvard decision, which said, universities may not simply establish through application essays or other means the regime we hold unlawful today. So in other words, you can't use application essays to achieve a certain racial balance, but you can use them to evaluate an individual applicant. So let's go on to best practices. The guidance establishes several best practices. We don't have time to go over them all here, but I did select a few to just go over because I think these are important. It's important to document legitimate, neutral reasons for why you're doing what you're doing. Make sure you have that, so if you're challenged down the road, you have a paper trail of that. Avoid race-based and national origin-based benefit awards unless strict scrutiny can be met. Do not apply gender balancing in awarding benefits unless the heightened scrutiny can be met. And using first-generation or low-income scholarship awards, make them open to all and award them to all, meaning from all groups, not just certain protected groups. And then with affinity groups, make them open to all and make that clear on the group's website and in the group's bylaws if you can, and establish a clear non-hostile environment policy. The last thing I'd like to go over is, so there's something, because all of these grant terminations in particular are talking about Title VI violations. Title VI prohibits entities which receive federal funding from unlawfully discriminating. Title VI does allow an agency to terminate a grant based on Title VI violations. And we have seen grant terminations that reference Title VI violations as the basis. The statute itself includes a process provision, however, there's a certain process that must be undertaken before a grant can be terminated. And basically it's notice, an opportunity to be heard, which is, just due process 101. It specifically mentions a hearing. And then it also gives the opportunity to voluntarily comply, which is really important. All of that is supposed to be done before a grant is terminated. Further, if there is a grant termination, it should apply only to the non-complying program as opposed to just terminating all the funding for, an institution as a whole. Note that while this process is there and it's there by statute, we are seeing grant terminations that are undertaken without taking that process first. This does provide for a subsequent Title VI failure to follow process claim that could be heard in a federal district court, but obviously that takes time. So, keep in mind that that while you may have programs that you realize, okay, I'm gonna take this risk because I believe in this program and I feel like the Title VI process will give me what I need. That this administration is not always necessarily following that. So The last thing I wanted to point out is the department is expected to issue proposed regulations relating to streamlining the process for pulling federal funding from those that it considers civil rights violators. We may see those as early as the end of this month. And any such regulations, however, would need to comply with this Title VI process because the Title VI process is statutory and the regulations can't regulate around that, so to speak. So thank you, Trey.
Yeah, thank you, Lori. I will add quickly before, I know everyone may have to drop here in 3 minutes. That's when our scheduled ending time is. Obviously, there's a lot to talk about. I will say we're running a bit longer. We do still have some takeaways and some other information regarding to the False Claims Act. We've got 3 questions in our queue. We received 2 questions prior to the webinar. We're going to stay here and we're going to finish the False Claims Act. I'm going to give some takeaways quickly before that for compliance into the DEI. But the presenters, all 4 of us are going to stay on. We're going to answer all the questions, but we completely understand if everyone needs to drop. I will say quickly before we get to the next secret word that if you're looking for some practical takeaway for compliance on DEI, our colleague, Scott Goldschmidt, whose email address is here, or you can email any one of the presenters. We are helping institutions do a thorough review of their DEI policies. We go through all the websites, even the websites you've thought about. If you're interested in that, please let Scott or me or Lori or Brand or Anna know. We'll be happy to assist you. With that, the next secret word is compliance. I didn't mess it up this time, so I apologize for the previous flub, but here we go. It's compliance, and we completely understand if people need to drop. But as I said, Anna will next discuss the False Claims Act and specifically the key TAM provision inside that act, and then we will answer all questions, and we'll stay here as long as necessary. But if you need to drop for other reasons, we appreciate all your time. And if you need the slide deck, it's available in the resource widget, or you can email any of us and we will provide it to you. Anna, this is a great segue to you to the False Claims Act from DEI. I think we're all aware of the administration's desire to find whistleblowers, specifically in the DEI area. They would love nothing more than to get their hands on emails from enrollment reps saying things about DEI, and so this is brought the False Claims Act, specifically the key TAM provision, into focus. And so I look forward to hearing what you have to say about it, Anna.
Thanks, Trey. So I'll try to be quick so we can get to questions. But obviously, as Trey just said, the administration is really clear. They expect institutions to eliminate DEI preferences. That creates a risk every time you sign a PPA. An institution is certifying compliance with federal statutes, specifically Title IV, Title VI, Title IX, and the DOJ is using the False Claims Act as an enforcement tool. Oh, that's there. But fortunately, there are some new defenses to False Claims Act cases emerging right now. So the False Claims Act has a provision called the key TAM provision, which permits private whistleblowers to bring a lawsuit on behalf of the United States government. And that provision was enacted during the Civil War, but 160 years later, the Supreme Court let us know that they're questioning whether or not it's constitutional at all. So in 2023, Justice Thomas and Justice Kavanaugh and Justice Coney Barrett all wrote a concurrence and dissent raising questions about whether or not these kinds of cases where the government doesn't intervene, it's only brought on behalf of a private whistleblower, is constitutional. And that wasn't a binding opinion, but litigants were picking up what they were putting down. And so since that decision came out, there have been several challenges to these cases by litigants wanting higher courts to determine whether or not the provision is unconstitutional. And the Fifth Circuit has also, in a concurrence only, it's not binding, weighed in with the same idea that it could be unconstitutional. So currently pending, there are 2 appellate decisions that we're waiting on, one in the Third Circuit and one in the 11th Circuit. Both of the underlying cases were a private whistleblower bringing a claim on behalf of the government, but the government did not intervene. In this first one, it was brought against a Johnson & Johnson subsidiary, and after the jury verdict was awarded of $1.64 billion, that is when they appealed to the Third Circuit, arguing that the provision is unconstitutional. Next, in the 11th Circuit, a lower court, a district court, issued a decision declaring the provision unconstitutional. This is the first decision that we have saying that the provision is unconstitutional. It's currently being appealed, and the arguments are currently scheduled for December 8th of this year. So we will get some more information on which way the winds are turning with that. Why does this matter? If the provision is held unconstitutional, it could completely eliminate private whistleblower actions if a broad view is taken, or if it's a little bit more limited, it could still eliminate whistleblower actions where the government doesn't intervene. Obviously, the government is taking a very vigorous approach to defending the constitutionality of key TAM actions because they are so lucrative for the government. I have some stats on here about the number of settlements and the amount of funds involved in those settlements. However, we do already know where 3 justices have aligned on this issue. They've already told us that they don't think it's constitutional. So it's definitely something to watch. There's probably going to be a circuit split between the 11th Circuit and the 3rd Circuit, and then they're going to petition the Supreme Court to weigh in. So as I've said a couple of times, the Department of Justice has let us know that they are using this as a hammer to come down on institutions that they believe are engaging in illegal DEI, and they are using certification statements to bring false claims acts against those institutions. So we have a couple of tips for defending key TAM actions here. Most of them target, like, if a case is brought, what should we do? We evaluate the strength of the allegations before the complaint is unsealed. So when a key TAM action is brought, the complaint is sealed and the DOJ investigates and decides whether or not they want to intervene. That time period is pivotal. It's a good time to proactively engage with the Department of Justice, frame the case the way that you want to, give them your narrative, and try to limit the scope before they make an intervention decision. If they make an intervention decision and they don't intervene, that's when we get to employ these constitutional arguments and argue that the whistleblower shouldn't be able to proceed without the government's intervention, and set the case up for that kind of challenge later. And I think that's it.
Thank you, Anna. We'll start with the questions. And again, I understand if people need to leave, but we received 2 questions regarding DEI prior to the webinar. And so, Lori, I'll ask you to respond to those, and may want to make sure your mic is live. One participant asked, are affinity groups still legally defensible? For example, a program for men of color that centers on the success of men of color, but still welcomes any student to participate. Lori, do you have any thoughts on that?
Well, the devil is always in the details, and we don't know all the details about the program that's referenced, but I do know that it raises 2 flags for the administration. That it raises gender and it raises race. The guidance states that unlawful segregation occurs when an entity organizes programs, activities, or resources in a way that separates or restricts access based on race, sex, or other protected characteristics. And the guidance certainly doesn't like mandatory groups that are of a particular protected group. Voluntary affinity groups aren't required participation by the entity, and thus should not be compelled segregation, which is what the administration is worried about. although they could create a perception of segregation and may foster a hostile environment. So what I would say to institutions which are really committed to continuing their affinity groups is to make sure that they're open to all, make sure that that's stated on the website and in the bylaws, and they cannot be a hostile environment for anyone else who wishes to join in.
One more question on that similar topic, Lori. Are we in compliance, and I assume you're talking about an institution, with DOJ's guidance if we use race, ethnic-based scholarships as a replacement for unfunded aid after the student is already enrolled? And Lori, I'm assuming the unfunded aid portion is talking about potentially this institution had a grant that was maybe awarded under the previous administration, specifically looking to award grants under DEI, and maybe that funding is now gone for the student, or maybe there's some other reason the student has lost funding. But would love to have your thoughts on about, could they use ethnic and race-based scholarships as replacement for this unfunded aid?
Trey, unfortunately, I think this administration views race and ethnic-based scholarships, even if it's after the student's enrolled, even after in those circumstances, as unlawful. I mean, if it's a race-based scholarship, it's got to meet strict scrutiny, and if it's a gender-based scholarship, it's got to meet the heightened scrutiny. And so, even in that situation, I think it runs the risk of being unlawful under this guidance.
Yeah, and you mentioned this earlier, and I, for those who are the non-lawyers, I mean, strict scrutiny, that the heightened scrutiny is a very, very difficult burden to meet. It's very difficult. So, just making sure that maybe some of the non-lawyers understand that's a tall task. Okay, we'll move to the questions and that we have in the question box. I mean, the first one, I think we can respond to the question directly, maybe via an email, but it asked does our law firm have a resource document on how to craft a comment as seen in the Federal Register for the upcoming negotiated rulemaking? I mean, obviously the one that is set for next week, that time period has lapsed, but the department has indicated that future negotiated rulemaking sessions, and they will be seeking comments to the rules. We encourage all institutions to issue comments, and we would be glad to send sort of a generic form that could be used. So we'll reach out to that question directly. The next question relates to, GE and financial value transparency. It says, can you speak more about Thompson Coburn's suggestion that schools resubmit their data, even if they submitted it on time in February? I'm guessing a little bit here, but with the upcoming deadlines of next Tuesday and next Wednesday of September 30th and on October 1st, I would think the recommendation relates to if new information is being requested that was not requested previous, if there's new information. But if you've already satisfied the award years in question, I think the suggestion to resubmit it would be if you had better information about maybe some of the earning metrics, that information is changing a lot. So that would be a reason to do that. And again, if that's not a full answer to your question, certainly we'll be glad to email or have a conversation to answer that fuller. The next question that I have is, Brant, I think this is for you. And again, everyone make sure your mic is live. Is there a difference between a contract cancellation versus a termination? I'm assuming this is in the grant context. So Brant?
Yeah, thanks, Trey. And I did answer that question in the chat box there, in case it was not seen by the individual who asked it. But yeah, there is a difference between a termination of a grant and what we call a non-continuation of a grant. A termination is effective immediately and is carried out through a particular regulation. It is 2 Code of Federal Regulations, or 2 CFR 340, and the process that follows a termination is different than a decision to not continue an award. when there is a decision to not continue award, it will not be effective until the end of the individual 12-month budget period. And likewise, the appeal process for a termination and a non-continuation decision is different. I did not get into those details during this webinar because I think people may have been lost, and because my colleagues, including Trey, have told me that when I get into those details, people tend to get lost. So that is why I didn't do that, but I would be more than happy to flesh that out offline with the person who asked that question. And I do just want to also go back to the difficult question about race-based scholarships, if those scholarships are being offered by institutional aid. You heard Lori answer earlier. I thought her answer was perfect. That is a difficult situation. There are any number of other similar situations that implicate, that present challenging questions. And those are questions that ultimately your institutional leadership will have to think about. And there's a risk-reward kind of analysis that comes into it. How deeply are you committed to serving a group of students? How concerned are you that if you do that, you will be the target of the administration's ire? Those are hard questions to ask, and the case law sometimes does not have perfect answers. But in this administration, in this environment, I would think twice about poking the bear, so to speak, because there is a lot of institutions are being penalized for things that for a long time have not been second guessed, and so difficult questions. But that was a great question, and I hope that provides a little bit of advice.
With that, I don't see any other questions.
Trey, there were a few others that came in when people registered, and they are on that email that I just sent to you.
Okay, let me look at that. We will answer those right now. Well, Lori, I see your email.
If you scroll down, so one is, it's my understanding that associates, bachelors, and graduates. Yeah, okay.
Okay. It's my understanding that associates, bachelors, and graduate programs now face strict earnings-based accountability, which puts them at risk of losing federal loans. However, it seems certificate programs are exempt from these thresholds. Are significance programs exempt? With gainful employment and the new accountability metrics, in your opinion, what has heavier weight to cause programs more to fail? Our institution has concluded that our own metrics for GE, but not the new accountability framework. The question is, which set of rules will cause more programs to become, I think it cuts off there, become more terminated. Okay, so I think the question is, what should institutions worry more about? If you're an institution that is subject to the gainful employment enforcement provisions versus the new do no harm framework. Again, some of this is reading the tea leaves a bit, but I think most agree that the do no harm framework is going to apply to all institutions equally. Certainly the GE enforcement rules do not. So what I think is that the GE enforcement rules probably have a larger risk to institutions if they are subject to the enforcement rules. But that said, we haven't seen all the details on the do no harm, so we need to be mindful of that. But again, I think you're thinking about that in the right way, whoever asked that question, and just keep paying attention to announcements from the department and from law firms and other secondary sources like us to keep you apprised about what is changing as it relates to GE and the do no harm. And I think there may have been one more question. Well, that's all that I'm seeing. That's all that I'm saying in the questions, actually. So with that, I know we've run a bit long, but we appreciate everyone participating today. I did see a question about the final secret word. They asked me to put the screen back up. I think I messed Anna up when I went backwards to try to do that in her presentation. I sort of forgot that was being shared by everybody. So if that participant was unable to answer, let us know. We'll try to help you out. But the last secret word was compliance. I don't know if that helps. But with that, thank you so much. Please fill out the post webinar survey. And if you have any other suggestions for us and our every other week litigation summary that we email, please let us know. But we appreciate your time so much. Thank you.